everybody. Just to let the online people know, we're still setting up here and getting our tech stuff all in a row, but we'll be starting really soon, and thanks for joining us. I think we're gonna get started now. And for those on the webcast right now, I think the comments function is disabled, so I apologize for that. We'll work on getting that enabled so you guys can participate in real time. I'm Helen Ling. I'm the chair of the membership committee this year for the ADR section. Thank you so much for coming. Welcome. We're really delighted today to have Serena Lee from the American Arbitration Association here to talk to us about arbitration and mediation. I'm just going to let her get right to it and have her give an introduction of herself. Thanks so much.
Thank you, Helen, and welcome everyone. So I'm supposed to hold the mic to my face. I'm supposed to have the clicker, and I'm supposed to talk and not walk past this black line. So there's a lot to be done here. So if I start stumbling upon myself, you can just direct me in the right direction. So as Helen had mentioned, my name is Serena Lee. I am the vice president for the American Arbitration Association. I ran the Seattle regional office for about 5 years, and about a year ago, I went down to San Francisco to run their regional office. I see many friends. I feel like this is a AAA reunion here. So always thrilled to be back in my hometown. And today, I was asked to speak about this topic of where mediation and arbitration intersect. In just scanning the audience, I know that many of you understand what mediation and arbitration was. When I asked Helen how much I should spend on what mediation and arbitration was, she did say that there were some of us, maybe online, maybe who will be viewing this after the webinar, who might need just a quick introduction. I'm just going to spend a real quick few minutes to make sure we're all on the same page, and then we'll move on to some more what I call exotic ADR practices, and I will invite all of you in the audience to interrupt me if you have questions. I am going to pose a lot of questions for the audience. This is technically not a lecture style type presentation. I am looking for discussion, and I don't have any answers. I have no positions. This is really more of a thought experiment. So let's get started. So I like this because this talks a little bit about what the dispute resolution continuum looks like. So for those of you who are in the room, I know many of you are mediators and arbitrators. I'm going to spend most of my time on the mediation and arbitration spectrum. But in looking at this dispute resolution continuum, you'll see that when you move from the left to the right, what we're talking about is parties who will be increasing their transactional costs and decreasing their level of control in the outcomes. So you start from the left, negotiation, you have a dispute, you sit down with the person that you're having a dispute with, and you try to work out a deal. There's no transactional costs, and you have ultimate control over what you want to the resolution to be in the dispute. And as you move to the right, you're going to get more and more transactional costs. You're going to maybe hire a mediator, maybe a negotiator to help you with the dispute. Moving all the way to litigation, where of course you've got the attorneys and the judges involved, and the outcome, of course, is no longer in your hands, but in the hands of the judge or the jury. So I'm going to spend, as I mentioned, the majority of my time between mediation and arbitration. Now, if you want to take a quick scan, I know that this slide is rather faded, but I'm not going to spend a whole lot of time in talking about the other techniques, including fact-finding or early neutral evaluation or a mock trial of that type. So I'll explain to you how we're going to get to the intersection between mediation and arbitration in a sec. So we'll first spend a couple of minutes talking about mediation. Of course, I like this slide a lot. I've been told that this is a copyright infringement. This is not, but I like it because, of course, any of us who are doing mediation would appreciate why mediation at this point would make a lot of sense. And for those of you who are on the webinar, essentially the caption states, suddenly a heated exchange took place between the king and the moat contractor. They're in the middle of a moat being built, and now it's not the time to go into litigation. So I think this is quite clever. So mediation, very, very quickly. I won't spend too much time on this. Again, to make sure we're all on the same page. Mediation, mutual voluntary participation. It is a non-binding process. And of course, third party neutral is hired to assist the parties in coming up with an outcome or a resolution. They aren't there to provide the resolution, but to essentially assist. Of course, the resolution is determined by the parties themselves. Again, the mediator, of course, is there to facilitate a settlement or a resolution. All of the information that's shared in mediation, of course, is confidential, and it's fast, and it's informal. There are no rules that the parties have to abide by when they're in mediation, and the costs are normally shared by the parties. There could be, of course, contractual obligations for one party to pay for the mediation, but the idea is that all the parties are in the room together voluntarily, and it's a process that they both all want to be involved with. Mediation. So very quickly, the styles of mediation that you might encounter would include facilitative. Again, the mediators there really just to help facilitate and to help the parties come to resolution by discussing the issues and possible outcomes. Evaluative is a little bit more hands-on, whereby the mediator may provide the parties with his or her opinion about the case and the merits of their and strengths of their arguments if they were going to move to litigation or arbitration. And transformative, of course, we see this mostly in the context of family law, where the parties, through the help of the mediator, come up with a resolution that actually, quote, expands the pie and can help preserve relationships and maybe even improve relationships based on the outcome of the parties' resolution in a mediation. The types of mediations that parties may find themselves in: joint session, whereby all the parties are in the room the entire time with the mediator and openly discussing everything that's on the table with the help of the mediator. I know there are some mediators who only do joint sessions. Maybe the more common type of mediation I see on the commercial side is a caucus model, whereby the parties are separated into rooms and the mediator basically does the shuttle diplomacy and they're shuttling back and forth. Of course, here in the Pacific Northwest and in California, I see basically a hybrid model whereby the parties might start out in a joint session and then they break into caucus after the initial administrative or the housekeeping is done, and perhaps sometimes the mediator might invite the parties to have opening statements. So very quickly, any questions? No? Okay. And I'm blazing through this, mostly because I know that everyone in this room understands most of what I'm talking about. So now we're going to move very quickly into arbitration. Of course, for those of you on the web, the byline says, the arbitration team is here. This is a joke. We don't do rock, paper, scissors. But I thought it was clever. Okay, arbitration. This is, of course, many of you know that arbitration is a creature of contract, meaning that usually parties are bound by an arbitration clause that's included in a contract. And it's clearly a much more formal process in relations to mediation. Usually, if the parties have agreed to arbitration, they will either have a identified process by the contract, or they are relying on an administrator such as WAMS or JAMS or AAA rules if they are going to go into arbitration. And in arbitration, an arbitrator or a panel of 3 arbitrators will render an award. So very quickly, arbitrators are usually selected in 3 methods, either by mutual agreement. They may just go, if I have a dispute with my adversary, we agree to use Mr. Mel here as their arbitrator, and we call that ad hoc, or a party agreed upon arbitrator. The contract may specify what type of method the arbitrators might be selected by. It could be a sole arbitrator that they either mutually agree on. They might actually name a person, or they may name that they are going to use a list from a local provider. Or they may just use an administrator, such as a AAA or WAMS or other administrators that have their own specific method in choosing the arbitrator. And finally, that the arbitrators can award costs and fees associated with the arbitration to the prevailing parties. This could be in the contract, or the arbitrator may have that discretion. Again, very quickly, arbitration, of course, is a very limited appeals process. So we often call this a one bite at the apple process, unlike in litigation where you might have an appellate option in an arbitration. The FAA, the RUAA, or your state arbitration rules really do limit the types of or grounds for which you can appeal an arbitration clause or arbitration award. And arbitration awards are generally confidential unless the parties agree otherwise. I just did a drafting clauses program for the Higginbotham Fellowship for the AAA, and I did make a good point that though the idea that arbitration is confidential because it's not in the public eye, if you are interested in making sure that your arbitration clause is confidential, you might want to put in language specifically stating that the parties are bound by confidentiality if confidentiality is important to you as a process. So the arbitrators, of course, are bound by our own ethical rules not to divulge any information. And of course, it's not in the public eye, but the parties are not bound specifically by confidentiality rules. This may not apply. Oh, yes, of course. That's a good point. What was that, Mel?
Enforcement may make the award public.
That's true. That is very true. So something to think about if arbitration confidentiality, you may want to think about how you're going to, if there's any way really, to preserve that confidentiality if the parties are seeking some sort of enforcement mechanism to in the public courts. I also have noticed also in some instances where in arbitration subpoenas may sort of breach the confidentiality of an arbitration. So, but that's something neither here nor there. So I'm going to talk now about where mediation and arbitration intersect. This is something actually when Helen asked me to come and speak on this topic, I wasn't entirely sure where they intersected. And I started thinking about how mediation and arbitration may start overlapping, and how mediation or types of mediation, aspects of mediation may bleed into arbitration. So what I'm going to do now is talk about some of the mechanisms that I have seen, and then I'm going to essentially invite the audience to talk a little bit about their opinions and some issue spotting of what each of these mechanisms might yield. So going back to this dispute resolution continuum, so you can see that from between mediation and arbitration, there are several different steps. What I normally see, again, this is on the contractual commercial contract is a usually two-step process, whereby if you see an overlap, it would be in the form of a step clause. So when I say a step clause, of course, it means that essentially the parties have agreed to go into either mandated mediation or negotiation before to go into arbitration or litigation. And I wanted to give you just a quick sample of what an arbitration step or a step clause might read like. So in a contract, it might read something like, if a dispute arises out of or relates to this contract or the breach thereof, and if the dispute cannot be settled through negotiation, the parties first agree to try in good faith to settle the dispute by mediation, blah, 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 before resorting to arbitration, litigation, or some other dispute resolution procedure. So that is what we call a step clause. Now, this is before the new AAA, what I'm calling the new AAA rules, which were promulgated on October 1st, 2013 came out. Because under the new AAA commercial rules, mediation is a condition precedent to going into arbitration. Now, I'm going to read you just portions of it. I did put in emphasis mostly to draw your attention to what this, quote, mandatory mediation step looks like. I won't read the whole thing, but essentially it states that the parties shall mediate their disputes. And then it says any party before they go into arbitration. However, any party to an arbitration may unilaterally opt out of this rule upon notification of the AAA and the other parties to the dispute. So while this is mandatory, what we're trying to say is that, listen, you can unilaterally opt out of it, but the reason and the thought behind putting in a clause such as this one, where one party can unilaterally opt out of mediation, is simply to draw the parties to mediation, to say you must have that conversation prior to arbitration. We as a AAA are quite aware that oftentimes you as an advocate may not want to bring up mediation, and this is our way of simply saying we're going to encourage you to have that mediation conversation. You're going to be asked several times before you get to arbitration if this has been satisfied. I, as an administrator for large, complex commercial cases, the first thing I do when I ask the parties to convene an administrative cause, have you tried mediation? Is it ripe enough? Have you tried and have you failed? And of course, this rule also states that you can go through the AAA mediation, or you can go to any other provider. We don't need or expect the parties to use AAA mediators. We simply say, try mediation. Now, the verdict is out, whether or not this has actually encouraged mediations to go up. The rules, again, was just promulgated in October. We're tracking this very carefully to see if this mandatory step will actually provide for more mediations to occur. The AAA, of course, is very interested in mediation because it settles the dispute quicker, but I'll keep you posted. I just want to very quickly ask, what is your reaction to this mandatory mediation step? Do you think it's helpful as advocates? Do you think this might promote mediation? Feedback? Yes. Nice and loud.
My experience with these is that it can be a good thing. It can be the mechanism to force the parties to talk first. The problem is, in any dispute, time usually works against one party. So before I have any kind of escalation clause at all, there's going to be a time limit to draw a fine line. So either party has the option after 30 days or 60 days. You're either going to settle it or you're not, so you can go right into arbitration. It doesn't act as a break or a pause for somebody that can be used to drag things out.
Yes. Oh, so essentially what this gentleman has said is that Pete has said is that absent a time limitation on this type of, quote, mandatory mediation, he doesn't think it would be fruitful, because essentially, I think what I'm hearing is you're concerned that this type of mandatory step might delay the moving of the arbitration. It can be. Does this change you anything if I were to say, if I read this part, absent an agreement of the parties to the contrary, the mediation shall take place concurrently with the arbitration and shall not serve to delay the arbitration proceedings. Does that change your mind, Lish?
It really doesn't change mine. I'm arbitrating a case now, and I'm arbitrating a case now, and one of the parties is saying that they're not going to go forward with discovery until they know whether or not the case is going to settle in mediation. So in that case, it doesn't help at all.
Any other thoughts? We're very interested in what, from the advocate's point of view, whether or not this actually makes a difference. So I'll keep you posted on sort of the statistics that come out from that. So I'll move on. So now I'm going to go into this idea of a mead-arb. Of course, in a mead-arb proceeding, the parties start out in mediation, and if the issues are not resolved in arbitration, they're submitted to, mediation, then they are submitted to arbitration, thus the mead-arb. And in this case, the mediator may serve as the arbitrator in the, if the parties agree. So again, this is a mediation that started. The parties have either agreed to submit some issue or the entire dispute to arbitration, and the mediator may now serve as arbitrator. Not necessarily, but they could be. So this is an example of mead-arb clause. I won't read the whole thing, but essentially it says that the parties agree to endeavor first to settle the dispute by mediation, and any unresolved controversy or claim arising from or relating to this contract, blah, 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 shall be settled by arbitration. So essentially it says, if we can't settle in mediation, we will go into arbitration. And it states there, if all parties to the dispute agree, a mediator involved in the parties' mediation may be asked to serve as the arbitrator. So, I'm going to contrast this with the Rule R9 mediation rule, which I just read to you, which says, unless agreed to by all parties and the mediator shall not be appointed as the arbitrator to a case. So what it really says between the two of these things is that while we say that the parties can agree to use the mediators or the arbitrator, it seems to indicate that they really shouldn't. I want to get some reactions on, well, first of all, how many of you in the audience have done a mead-arb? Okay, welcome. So I wanted to ask a question. So what are the advantages and issues with a mediator serving as a subsequent arbitrator? I'm going to pass along the mic because I'd like to actually hear from the arbitrators in the audience.
I don't even understand the concept, because as a mediator, we're supposed to say whether or not we know the parties, whether we've had any relationship with the parties, whether we have any reason to believe that we may have biases. And there's no way that you can go through a mediation if both parties are actually telling you a lot of things and remain unbiased. So you start the arbitration as a biased arbitrator, it seems to me, and somebody may tell me that they, have a halo over their head, but I don't believe I do. I just don't see how it can happen. There's one thing that I have done that may touch on this, and that is after a successful mediation, and they write up all the conditions of the mediation, I have agreed to interpret what the intent of the mediation was if the parties disagree after the fact, but that's not arbitration.
There were others.
Internationally, it's more common and more accepted than in the United States, ranging from China, where we would be aghast at what we would consider conflicts, and yet there's a long tradition. I just heard of a German, apparently very common, that the arbitrators, after they've heard the case, may propose a settlement to the parties and say, after hearing the case at this point, we'd like you to consider this. They don't get involved as mediators, but it's sort of a half step.
More evaluative? Yeah. There were others here on this side. Carol, sorry.
Yeah, but my field is labor and employment, and I'm a full-time neutral. Why sometimes the parties do want the mediator to go on and decide it is it saves on education. If they're comfortable, if they've used the person, the neutral before, and they're comfortable with them, it is sometimes short tracks a lot of things, which is usually why they want to use the same person. If they're not comfortable, they'll usually request a different arbitrator if they're not successful in the mediation.
I'm Tom Kilbane. I have primarily been an advocate in these things and in the environmental law context, and it's quite common to have clauses like this in the environmental law context, even though, like, some of my former partners who were trained as mediators are aghast at the very idea. But it does, I think if the mediator is more evaluative to begin with, it also makes for a really short arbitration if you have to actually go to it, because everybody will kind of know where you're coming from anyway. But one advantage is it does save time and saves the learning curve, education process. But I think it would be hard to go from being truly a neutral to then rendering a decision. Truly a mediator, a facilitative mediator, it seems harder. But at least in the context of who's going to pay how much to clean up a site, it seems to work pretty well.
Hi, my name is Ellen. I'm actually a hearing officer with the Seattle Public Schools, and that is the format of the hearings, of all the disciplinary hearings, which is they are, depending on who you get as a hearing officer, the mediation part is taken more or less seriously, but I'm trained as a mediator, and so I take that very seriously. And basically my goal is to mediate as many of the cases as possible. But what I find is often people won't agree themselves to something that they're perfectly happy with when someone else imposes it. And what I find is after a certain amount of mediation, often, most of the time I actually do get a good result in a settlement coming out of mediation, but I will then, say, well, if we can't mediate this, and we'll switch to the hearing mode, and at the end of the day, I come up with a decision that is a place where the parties could have gotten to themselves if they had been a little bit more willing. People wind up being, I think, happier with the decisions coming out of this kind of mediation arbitration process because the trier of fact really understands the interests of all the parties.
Well, thank you for that. I was actually quite interested to hear from those of you who were either serving as neutrals on how you deal with MEDARB, and those of you who are advocates who might agree to MEDARB. So the points of views were very, very interesting to me. And when I very quickly thought to myself, well, why would you, as a party, want MEDARB? Of course, we've talked about this in some instances. The pros, of course, cost savings is a much more efficient process. Sometimes the idea is that there is a mutual trust in the neutral that was selected to serve as your mediator, and perhaps that makes for a more rich and more satisfying procedure for those who have to go into MEDARB or select MEDARB. And there is finality. At the end of the day or at the end of the week, you're going to come up with a mediation or an award that is based something maybe a little bit more satisfactory than an arbitration where again, the level of control that you have in the outcome was maybe completely out of your hands. Cons, of course, the parties, I think maybe the biggest issue from the party's point of view is that if I know that you may become my arbitrator, I don't know how forthcoming I might be as a party in mediation. And maybe I'm going to hold back one or two facts, and maybe the mediator isn't really going to really truly understand the interests of the parties because they're afraid of what the process may turn into if they go into arbitration. You know, Lish was telling us of a story where he, as a mediator, found that he really disliked a party in a mediation, and when they approached him to do work afterwards, he, as perhaps in the future as an arbitrator, he said no thank you. I think that's a very valid reaction to someone where you say, listen, I heard all your dirty laundry, and I don't think I can be unbiased towards you as an arbitrator. Settlement may be less collaborative. I think, again, from a procedural point of view, if you find yourself in a mediation that may turn to arbitration, you may, again, be gaming the system a little bit, and instead of truly working out with the other side on a settlement or a resolution that makes more sense, you're still trying to game the system a little bit, hoping to sway the mediator, who may then become the arbitrator, to see your point of view. So again, you might be gaming the facts a little bit, and I just don't know whether or not that is as a collaborative process as if it was a true mediation where you knew that at the end of the day you may have to walk out and start arbitrating this thing. So let's really talk about it as a party in a mediation ought to. And lastly, I think there is this issue of, and I think a couple of you have touched on this, which is the ethical dilemma of if you found out really damaging information as a mediator, can you then shield yourself as an arbitrator and say, well, they shared that with me in confidence. Now I'm going to try to render an award as an arbitrator, even though I'm not supposed to share or take into account the damaging information that the parties have shared with me. I don't know if schizophrenics are better at this than others. Right. That's true. Well, any reactions to that? Carol.
An arbitrator decides the case on the evidence presented in front of them, very similar to a judge or a jury, and cannot consider anything outside. So what they heard in the mediation, if they're going to do it properly, they cannot consider in the arbitration unless it's presented as a piece of evidence.
Any reactions to that? I saw a reaction. I saw some reactions.
This is Mel, and I think what's actually being ignored in that statement is that the parties are real people. And in the mediation, the arbitrator is going to learn more about the individuals than the arbitrator might learn in the arbitration. Inadmissible evidence will come in the mediation, and the arbitrator can't really unring the feelings that result. The arbitrator may enter the arbitration with a bias as to the credibility of a party, for example. And if it were just an arbitration without that pre-existing experience, the result could be different from what may happen in a med-arb.
I think that's a valid point. Myself, if that situation occurred, I'd step back. You'd step out if you felt prejudiced against one party or the other. I would step out as an arbitrator. And actually, I've done that once and just said, get somebody else for this. Because if you're deciding a case, if you're the final decision maker, you really cannot be biased on one side or the other. You really do have to step back. And sometimes that's hard, but that's what your job is.
I just think that's fraught with danger, and that you're setting yourself up for potentially being sued at some point, because our system does not allow a juror with a bias or prior knowledge of somebody to sit on a jury if they're honest about that information. They don't allow judges to exert their personal opinions, and I've been a judge, an advocate, an arbitrator, and a mediator, and I don't think I can always put aside what I know. I think that the ethical dilemma, both for you and for the parties, is pretty apparent.
Okay, well, I'm going to move on. This isn't quite arbitration, but I just wanted to make mention of this, partially because I was just curious of this phenomenon. I see it, and I wanted to bring it up to the audience as maybe, and I brought it up partially because I think there are some aspects of mediation in baseball arbitration, but let's just get through it very quickly. So for those of you who are not familiar with baseball arbitration, of course, this is a situation where the parties essentially will offer a final settlement or best offer to the arbitrator or the arbitrators, from which the arbitrators have to essentially choose one. Of course, in this instance where the parties are limited to a number, the idea is that then the parties will submit a number that is more reasonable if, in hopes that the arbitrator will choose this option. And of course, this was usually originally used to settle salary disputes between baseball players and their owners. Of course, this is an example of what a baseball arbitration might look like. It reads, each party shall submit to the arbitrator and exchange with each other in advance of the hearing the last best offers. Arbitrator may be limited to awarding only one or the other of the two figures submitted. I'm also going to just mention very quickly baseball, or what we call baseball arbitration, whereby in this scenario, the arbitrator is never told what the two numbers are. They do this evaluation independent, and the parties have agreed to submit their final numbers to each other, and the person who's, or the party who's, she's laughing, whose settlement amount is closest to the arbitrator wins. So I've seen this one as well. And just a quick raise of hands, how many of you have actually been involved with the baseball arbitration? One.
It's actually in a mediation context sometimes. Sometimes it comes up in a mediation context where you're reaching the late stages of a mediation and it's hard to make further movement. The parties may agree to a system, either baseball, night baseball, or something else such as overlapping offers that result in a final solution, but it is a solution that's based on something other than actual negotiation between the parties. It's something like this.
There's a Canadian fella at Baker and McKenzie in Tokyo who has sort of a twist to this, and that is he will finish the hearing and go in and put down an envelope and say, here's my award. If you would like, I'll give you a day to come up with a number for each of you, and whichever one is closer, will win. You have a choice. The advantage is that if you wait until after the hearing, in most cases I've been associated with, stuff comes out that's a little different. So the number you put down at the end of the hearing might be a little different from what you might at the beginning, since you've had the benefit of the whole thing. He said when he's done this, he said probably he's done it 10 times, 7 times the parties have taken him up on it, and all 7, both numbers were pretty close to what the award is that he would have given.
My question is, I'm curious that of the 7 or the 10, why they didn't just settle? Did they actually go through with it? Why wouldn't they just settle it, right? So I was talking to an experienced arbitrator who was in the middle of an arbitration whereby it was baseball arbitration, and I was talking to him about it because I really don't see this often. But I found it interesting because what it does is it actually does force the parties to have a conversation, either with themselves or with each other, about whether or not going to go through with this baseball arbitration. And the arbitrator that I was speaking to, who was involved with this arbitration, said he likes to see these baseball arbitrations because he knows more likely than not they'll settle. So I'm curious to hear that on the international side that they actually go through with it. They actually want that envelope to be revealed. It seems to me that domestically, at least anecdotally, that with baseball arbitration, we see a lot more settlements. So I thought that was kind of exotic. I put this in partially as a thought experiment. I don't really see this. I've not seen this before, but I thought I'd bring it up because I think it's interesting as a spectrum where it could potentially happen, where of course we flip it. We start out in arbitration and the parties go into mediation. Now there's two flavors of this, of course. It could be that you start arbitration and in the midst of it, the parties agree to stop and go into mediation and to go in and mediate it. And the arbitrator waits patiently for the mediation to yield some sort of result. And if the parties do not actually come to a settlement in arbitration, then they move back to arbitration and continue on. In this instance, of course, when I see this, the parties usually just choose a different mediator, and they may ask the arbitrator to mediate. But I wondered, again, this is a query, is how many of you would do it? You know, I think many people would have an issue with it, maybe less so with MeadArb. But I wanted to bring this up because I wanted to hear from the audience. What do you think about ARB-Mead? How many of you would actually go from arbitrator to mediator? Show of hands. Oh, you got 1, 2, well, 2, 3.5, 1 with a maybe. Why would you do it, Carol?
Requested, but what I find is that this scenario is not what most people think of as mediation. It's really settlement discussions, and it usually, my experience is that it's occurred is during the arbitration hearing, evidence has come up that this one side or the other had no knowledge of, and it changed the picture. So now they want to discuss the picture, and they may want you to facilitate the discussion, or they may just go out and discuss it themselves. I just had one that exactly happened, and they ended up settled. They didn't use me, they just settled it themselves.
I think it's kind of a unique situation. I think in any kind of, arbitration mediation or mediation arbitration situation, they don't fit nicely into the kind of squares that we see in court. And a lot of the considerations like evidentiary issues, they don't really exist in every single case. A lot of cases, basically what you want is to get as much information into evidence as possible so that the arbitrator can make the most appropriate decision. And I think that's the kind of situation where you could move into mediation to help facilitate a decision.
Were there any comments on this side? Mel?
There are a number of circumstances I can think of and have experienced where this would be useful. The important point, I think, to make in this is if you as an arbitrator agree to shift into a mediation mode, then you need to make clear that if the mediation doesn't work, you're not available to continue the arbitration. And that's the key. But if you're interested, I can tell you some other situations in which it really made sense. Well, I had one arbitration where the parties had a very extensive negotiation, but they really didn't get what the other one was saying. They didn't understand what was being proposed. They misunderstood it, probably because of their own perspective. And so once we got into arbitration, and they understood the applicable law and how some of the issues they were concerned about either did or didn't apply, it just would make sense to settle because some of their concerns no longer existed. There was another situation that went into arbitration because one party had been trying to get the other party to commit to a multi-million-dollar expenditure, and they'd been working at it for months and months and maybe even years, and they just couldn't seem to get the other party to make that commitment, and the last commitment they had was $2 or $3 million instead of 10 times that. So they filed for arbitration, not knowing that the day before they filed, the other party had actually prepared a letter to send to them to do exactly what they wanted. But once they filed for arbitration, that came off the table, and that information wasn't even disclosed until way down in the arbitration process. So there was a year-long delay before we got to the point where we could have been a year earlier if that information had come out.
And Pete, why were you waffling on whether or not you would do this? I'm curious, because you had some concerns.
I waffle a lot. I think we go back, suppose you do the arbitration, you get into mediation, and suppose it fails. So then you're back into arbitration, and then you have all the stuff that Lish and everybody else has brought up. You now know stuff. A common tactic in mediation is tell me, I won't tell anything you tell me unless you agree, and so forth. And so if there were narrow issues and you got good waivers and all that. The other thing I'm concerned about that hasn't come up is that if it's a big deal and the loser is really unhappy, there may be a way to pull out of this a ground for appeal based on bias, well, you said in the mediation or something like that. So if it were clean issues or something, I might, but I'd be very careful. And I think I'd want to feel that there's a pretty good chance that there would be a settlement.
I think we would all agree that, right? I'm seeing a lot of head shaking, saying absolutely. We're pretty confident that it's a very narrow issue or very close, and they just need someone to pull the trigger, so to speak. They aren't willing to do it themselves. They just need that other party to say this is what should happen, and everyone goes home happy, right? Okay. Okay, well, that was a fun exercise. I threw this in partially because I was thinking about, as a mediator, how you might, in your head, go about asking yourself, can I do this? Should I do this? Will I do this? And so, this is pulled from the Model Standards of Conduct for Mediators. Of course, this is promulgated by the AAA and also by the ABA. This one was issued out in September 2005. I don't know if there's been a new revision to it. I don't think so either. There was maybe talk of some, but of course, we don't have to read it all, but essentially, I pulled up A, which is essentially that the mediator shall maintain the confidentiality of all information obtained by the mediator. We know this to be true, and it says if the parties into a mediation agree that the mediator may disclose information obtained during the mediator may do so. So then the query is, well, does this allow the mediator to serve as the arbitrator in MEDARB? Does this give you a pass if the parties disagree on the information that they can share, or do you think that's enough? Yes? Yes, that's true. I have mentioned the statement, of course, you also have to look at the statute in your state. And I did mention the RUAA and, of course, in any other state statutes that govern you. So then the other question is, so then does this impact how forthcoming parties are in mediation if they know that, again, this is a thought exercise. If I know that I'm going to mediation that may turn to arbitration, maybe I'm going to hold some information in my back pocket so not to prejudice the mediator against me, who would then maybe be the arbitrator, or I would just want to paint a rosier picture, then I would. So I think that's one of the issues I struggle with from the MEDARB point of view.
I think it's the opposite usually, that parties want an opportunity to vent. They want an opportunity to lay it all out, everything they're feeling, everything they're upset about, why the other person is nasty and how much they've suffered. So they're not likely to hold things back in that sense, but then by that venting process, they've put all this information that an arbitrator would not know about. Plus, the attorney has not been able to control the client's testimony in presentation to an arbitrator. So I would be more concerned about that side of the equation than the failure to disclose.
I think it really depends on what kind of law you're talking about. I mean, I think two contractors that are disputing with each other are not going to be emotionally involved, and they may play all kinds of games. So.
Cameron laughed.
Well, I was actually just thinking that I'm a family law attorney and mediator, and I love the MEDARB model. I'm trying to push it in Tacoma area. I find it saves a fortune in fees. The comments about the neutral becoming a decision maker and being biased, I've yet to find a judge who's unbiased. I mean, after they've heard testimony, they're going to like or dislike one or the other, both of the parties. And I find in family law anyway, better decisions are made with more facts. So withholding facts doesn't seem to make sense. So that's the reason I'm here today, is because I've had a lot of pushback from other people regarding this model, and I wanted to hear what the arguments against it were, because all I see is a much cleaner, easier way to resolve issues. And if the parties know going into the mediation that they've already chosen a neutral who's willing to do this, they trust, usually the attorneys have a history with this particular neutral, trust their decision making, and you know, everybody's case has warts. So the person that you hopefully don't end up even going into the arbitration, you settle it through mediation. And I've had very few of them actually that of the few I've done that have been this model, actually go to the arbitration phase. They almost always settle, because there's the threat of, well, we'll get this done one way or the other, or we won't start over again.
Interesting. Ellen?
Well, it's not the kind, mediation arbitration is not going to replace standard litigation. And I think family law is the kind of place where it's just perfect, because you have a situation where everybody in the room knows what should happen, including the mediator / arbitrator, but emotions are high and people are just not going to give in for reasons that don't make sense. And so at that point, rather than going in for another 7 hours of mediation, if the mediator can just put on an arbitrator hat and say, okay, kids, this is what you're going to do, it makes so much sense.
And I guess the one thing I would add, in case anyone doesn't know this, is that you cannot arbitrate parenting. You can agree to do that, but it cannot be binding. You always, always, always have the ability to take that before a judge. So you can take care of the parenting plan and all that, but if someone is truly aggrieved, they can litigate that issue. So even if the parties agree to binding arbitration, the parenting issue can't be binding.
Okay, so maybe that's the distinction, is you're telling me something that on the commercial or employment context that's different, is there is no end review. This is it, you know. So you're going to put a lot of trust in the mediator / arbitrator, who, I'm not going to say that they're not bound by by law, but technically, you know, they can do lots of things that may not fall in the purview of what a judge could do or may do. And, you know, mistake of law, it doesn't matter in arbitration. I mean, not that it does, you know, I'm just simply saying that the fear is that you don't have that avenue for commercial arbitration.
Another big difference is, it sounds like in the area of family law, you are interested in what the people are like who are involved, that's part of the process that you need to find out. And in a commercial transaction, that's not part of the process, and in fact that's something that should stay out of strictly economic commercial decisions. And so, I mean, in my mind, and I don't practice in that area, it does make sense, because that information that would be remaining confidential in a commercial context doesn't need to be confidential in the family law context.
Okay, I see we're almost up actually to the bottom of the hour. I think we have to end fairly soon. I just want to make a couple of quick mentions on things you may not be aware of, especially if you don't practice construction law. Our DRBs, dispute resolution boards. This is where either 1 or 3 members of the DRB serves as an advisory committee. They usually, as a board or as a solo, provide guidance, or the parties may submit what we call formal rulings to the DRB. And the rulings, though, are non-binding. I bring this up partially because we're seeing a small but steady increase in the use of DRBs in the construction context. And I just want to bring it to your attention because we do see it in situations where the parties have an ongoing relationship. It's long-term, and there's lots and lots of players along the way. This might be an interesting thing for you to look into, partially because I think that there are different applications. On the international front, you see this a lot, quite a lot. In fact, you're hard-pressed to not find a DRB in a large international construction project. So they find this model works really well. This is not informal arbitration. These hearings that you may hear about the DRBs holding, they are advisory, and you can, as a party, make DRB rulings binding, but normally they're advisory. And I bring that up only so that you can find out a little bit more about it. The DRB Foundation, another nonprofit organization, is very active. We have many founding members here in Seattle, which is why I bring it up. And the AAA and the DRB Foundation have worked very, very closely on promulgating rules and also identifying this process and promoting this process for parties who may be interested in it. I highly recommend, if you're interested in finding more about how DRBs work, to go onto their website. They offer fantastic training, day-long, 2-day-long trainings that I've attended. So if you're interested, you can talk to me a little bit more about it, or you can jump onto their website. There are many folks here in Seattle who are very, very active in promulgating the rules as well as promoting the use of DRBs. So there's a sample clause. You can look this up. I'm trying to get us to end on time. So I think that's it. Any questions, comments? Yes, Tom.
The one comment I have is that in the environmental context, again, and this is also very popular in Seattle and in the Northwest, is when you have these multi-party mega Superfund sites like the Lower Duwamish Waterway or in Portland, the Portland Harbor. These things are miles long. There's hundreds of parties potentially responsible for it. It's common to have what they usually call an allocation process. It's kind of a hybrid of sort of informal arbitration and sort of mediation. The parties hire a third-party neutral or maybe more than one to serve as an allocator. The parties and the allocator typically cooperate in designing the process. What are the rules? It's considered a voluntary process, but the liability scheme, like under CERCLA, can put a lot of pressure on parties to participate, because if they don't and then later they get sued, they can be considered recalcitrant and end up having to pay a premium for not participating. So it's a very interesting process. The parties in the allocator typically design, come up with their own rules for fact-finding and summary legal determinations. And then the allocator ultimately comes out with a proposed allocation of liability, either for cleanup costs or natural resource damages or both. And then it's up to each party whether they want to accept it and agree to settle on that basis or not. But again, a lot of pressure is brought to bear to force parties to do it. One of my former partners who does a lot of arbitration says, Tom, we already have rules for these things. We call them the Federal Rules of Civil Procedure, or the Federal Arbitration Act, or the AAA has rules or whatever. But I just bring it up because it is at this unusual process at the intersection of mediation and arbitration.
Any reactions to what Tom had said? Helen, do we have any questions online? Okay, well, I think this might conclude my presentation. I thank you for your time. I thank you for the discussion. It was very valuable. Thank you so much.
Well, thank you everyone for showing up and for for participating online for those on the webcast. But I just wanted to give you a thank you gift.
I love smoked caramel.
And this, just to remind everyone, this is just one of our many membership events every year. This is the third one this year. We have one coming up September 18th, and it's going to be on updates in legislation. There's been a lot going on in terms of ADR this year, and our very own executive committee's Paul McVicker would be helping us with that panel as well, so please join us for that. And we also have a nice spread in the back of the room. For those who are here to join us, sorry, those online, you are missing out on some really nice food. And if you have a drink ticket, you can cash that in at the bar behind you.